It's like, okay, well, we need a copy of your driver's license. We need a copy of the, we need you to fill out this form that you're claiming this as, and here's what your options are. And we need letters testamentary from the probate court. And we, whoa, wait a minute. Letters testamentary from the probate court? I thought this avoided probate. Hi, Jeff Mersacci, the Plain English Attorney, and welcome to the video. Today we're going to talk about 5 ways that your bank sucks at estate planning. Okay, so let's go ahead and start right off by saying, look, banks are great institutions. They do what they're supposed to do, which is hold deposits, make you a little bit of money, keep everything secure, make sure that you're protected and your money is there and it's safe within all of the federal guidelines. And some banks also offer these other services, maybe through either an affiliated company or directly with the bank, where, okay, we can help you with your investments, but they are not estate planning attorneys, so there's only so much they can do. Well, what exactly do banks do when it comes to, quote, estate planning? They have features on accounts where they can have a pay-on-death beneficiary. They can set up an account so it's joint with the right of survivorship, so it, quote, automatically passes without probate, and we'll get more into that later, to another beneficiary or the co-owner. So yeah, they can do this, but they are not estate planning attorneys. So what we're going to do is we're going to set up this example, and I'm going to run through these 5 things and even giving you a bonus one, so wait till the end because this is a big one. And we'll talk about the estate planning piece of it, and, well, look, maybe talking with an estate planning attorney is a much better alternative than going to your bank and saying, hey, I want to set up my estate. If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel. Now, most people don't do that. It just naturally kind of comes into the conversation when they're setting up accounts or changing accounts. So, okay, first thing, let's use an example. We've got John and Jane Doe, and they've got 2 kids, Jimmy and Jessica. Okay, so they're younger kids, and they're talking with their banker. Yeah, so we've got these accounts. We want to make sure the bank has all of our assets, including, we've got a brokerage account through the bank, and we've got our savings, and okay, we've got our IRAs, and maybe we've got some 401ks outside with the company, but everything that we have control of, we're investing, we're putting with you in the bank. Great. How do we set up our estate planning? All right, so the first reason why the banks suck at estate planning is it's not what they're designed to do. They are not attorneys. They are not authorized to practice law. In fact, this becomes a bit of an issue, and several years ago, it was a huge issue with people at the bank actually telling some of my clients, oh, don't do what the attorney said, do this instead. No, that's crossing a line. So let's talk about exactly what that practicing law, which is what attorneys are supposed to do and what the bank isn't doing for you. Attorneys are on your side. They're to provide you direct legal advice. Here's your situation. Here's how it's applied. When banks talk about pay-on-death beneficiaries or joint with the right of survivorship, they're allowed to discuss, and it's kind of a First Amendment but commercial First Amendment issue, they're allowed to discuss, here's what this account does, here's this feature where it pays on death and it avoids probate, or here's what joint with the right of survivorship means. They're not allowed to take that one step further and say, here's what you should do. If they cross that line, they're practicing law. And technically and actually, if an attorney gets wind of this, they really should be reporting that bank person and the bank to the state bar for the unauthorized practice of law. At least in North Carolina, that's exactly the way it is. They have crossed that line. So the banks are not your attorneys. Do banks have attorneys? And I've seen this get set up, and it's actually a decent resource if they're doing it the right way, and they offer it usually to much wealthier clients. We have an attorney on staff, and they can discuss, here's what are some advanced strategies, here's things that you can do with your estate planning, but they're always smart enough to say, you need to get your own estate planning attorney. They don't represent you, they represent the bank. And so they shouldn't be giving you legal advice. But now they can talk more about concepts that you're just regular banker or even your regular financial advisor, if they're not well versed in this, they can come in and say, okay, here's exactly what a revocable living trust does. Here's what a will does. Here's what probate is. So they can provide this background education, but even they're not, if they're attorneys, they're still not going to cross that line and tell you, here's what you should do in your situation, because you're not their legal clients. They work for the bank. So that's the first thing. They're not attorneys for you. The second big reason is sometimes banks will actually have estate planning documents. Oh, great, I can go to my bank and I can get a will or I can get a trust. They can have these form documents. And I've seen this in the past with a couple of the bigger banks. Here's a template that you can take and do what you want, but that's like doing it yourself. So the bank isn't actually saying, here, let's sit down and we'll help fill this out for you and provide you advice on the different choices and options. No. Banks will sometimes have these form documents. There's also something that actually ends up being extremely helpful for your estate planning attorney. If for some reason, and I'm not really recommending this, you want your bank to end up being a trustee down the line, they have specific language that they recommend be in the document, which just kind of helps them run the trust the way they're used to doing it. So bank trust departments have their own sets of processes and procedures, and here's how we handle things. And having the language in there helps them do their job the right way, as opposed to it just being general. Again, I don't really recommend banks be the trustee. Now, there are some financial institutions that do a lot more on the investing end, and I'm not going to say it's hit or miss. It's just I've seen track records where some companies do this the right way, some really don't. What I can tell you is banks, by and large, if they're the trustee, they're not really handling it investment-wise the right way. They still, in 2023 and beyond, there's still this knee-jerk reaction. Let's liquidate everything and put it into bank CDs in our bank because then we know it's safe. Well, no, that's really just kind of padding their resume. Say, look at all of these assets that our bank trust department has under management. Look, we've got in our bank. Here's all this money that we've got in our bank. Well, it's because they didn't put it into stocks and mutual funds and other stuff in a diversified portfolio. That would be the best thing for that beneficiary. It's nope, we know it's safe, we're putting it into the bank, in bank CDs. Okay, they're the trustee, they get to invest it that way. But that's, again, just another reason why the bank is just not really set up to handle things for you. So even if they've got those form template documents out there, they can't really help you use it, and it's just as much as a do-it-yourself, go on the internet, check out some YouTube videos, and start writing yourself. They just kind of giving you the outline. Okay, it's almost guaranteed to be a disaster, but if that's what you want to do, yeah, okay, I don't recommend it. The third reason banks suck at estate planning, it's because it's usually one-shot avoidance of probate. Now, I mentioned that banks can set up accounts so it's payable upon death to a beneficiary so that, quote, avoids probate. If it's joint with the right of survivorship, okay, it avoids probate. But that's really it. It's just this one shot of not going into the actual probate court process where it needs to be listed on inventories and providing all this information on, data, death values, and all. Okay, it avoids that probate, but it's set up for one shot. For example, let's use John and Jane Doe and their two kids, Jimmy and Jessica. They might have the contingent level. So if it's John's account, it's payable upon death to my wife, Jane Doe. If she passes on, then it goes equally to my children, Jimmy and Jessica. Okay, but it doesn't list anything about what happens. Well, what if Jimmy passes on, and this is decades down the road? Jimmy's got kids. Most of my clients would want it to go to those kids. And if it is going to those kids, then maybe it's that they want some supervision and some types of age limits. These accounts just have like either 18 or 21. That most people agree that's way too young for any type of significant inheritance. So if you're trying to avoid probate, having these things set up on pay on death beneficiary designations or just making them a joint owner on the account, it just doesn't make sense because they're way too young at certain ages. So it's not a universal thing where this is what you should be doing for estate planning. But the banks, they don't know it. And they're not really allowed to go too in depth into why it would be a bad idea. The best they can do, and they often do this, they say, look, you just need to get your estate planning attorney. I can describe, here's what these things do, but I can't recommend a course of action. At least if the bank's doing it the right way, that's how they're handling it. A fourth big downside, there's no executors or trustees set up on these functions. So in other words, okay, if it's payable upon death to the kids, again, we talked about the younger beneficiaries, there's no one overseeing it and watching that until they reach that certain age. It's going to them automatically. Now, that could send in a whole other host of problems and issues. If it ends up in probate and needing a guardian assigned, then they can work with the guardian. But again, it just ends up not really avoiding probate because there's going to have to be some kind of oversight if the kids are younger. So just naming them as beneficiaries to avoid probate does not work. It's also not specifically saying, okay, I want this person to kind of oversee this whole process. That's dependent on who you have in your last will and testament as an executor in the will. And if you don't have that, okay, it's open to the court to try to decide who's in charge. You're not getting a lot of control if you're just using the bank for your estate planning with joint with a right of survivorship or payable upon death designations only and not doing your own estate plan. The banks just aren't set up to give you the right kind of legal advice on here's who you should have as executors and then going ahead and empowering them. In fact, if you do have somebody in its power, they've got, okay, here's this checklist of stuff that we need from them in order for us, according to our bank regulations and state law, to actually deal with them and give them control over these assets to oversee these younger beneficiaries. So that's the fourth big reason. All right, so what exactly is the fifth big reason? And this sometimes gets right to the wealth management side. It will vary, but in a lot of cases, the banks only have a limited amount of resources for investments. So you're stuck with here's the handful of investments that we're okay with, or here's the handful of life insurance things, even though it's wealth management that we're going to offer you. It's limited by what their bank does, and it's not out on the open market. A lot of financial advisors are out there. They work with a particular company, but even then they have several options when it comes to different investments and things like that. In fact, if they handle stocks, bonds, and mutual funds, then there's usually a very wide variety of stuff that they can do. Even if it's only through one company, they've got access to all those stocks and investments through that one company. If it's on the insurance end, if they're, quote, a captive agent, then they've only got what their company offers. And I tend to see a lot of that same stuff with banks. They've got a very limited amount of life insurance, annuity, and other of those, quote, guaranteed safe investments that they have access to. Okay, so that's the fifth big reason. Now let's go ahead and give you that bonus reason I talked about at the very beginning of the video. It's another reason why the bank sucks at estate planning. It's on the settlement end. There are a few banks out there despite saying, hey, all of our accounts are, they're beneficiary driven. We've got it set up as joint with a right of survivorship or that's payable upon death. It avoids probate. But then when someone comes in to try to get control of it, even if they're the beneficiary, it's like, okay, well, we need a copy of your driver's license. We need a copy of the, we need you to fill out this form that you're claiming this as, and here's what your options are. And we need letters testamentary from the probate court. And we go, whoa, wait a minute. Letters testamentary from the probate court? I thought this avoided probate. Well, yeah, it's not a probate asset, but it's a piece of paperwork that we need in order to do our job. Whoa. This is a distinction that's really deceptive. And I've seen some actual financial institutions, they handle the stocks, bonds, mutual funds, and other stuff like that, as well as banks, because some of them, especially the larger ones, they're doing both of those functions. They just tell you, oh, it avoids probate, which technically it's not a probate asset, but they're demanding paperwork from the court in order to process stuff. My clients look at that and say, yeah, that's part of probate. So it becomes very frustrating that the families thought, oh, this was all set up to avoid probate because the bank said so, but they're requiring court paperwork. How does that avoid probate? And now I've ended up having to explain the difference. It's like, look, sorry, you kind of got lied to, sort of. It's a technicality. Technically, it's not in probate because it doesn't have to have the inventories and whatnot. Look, anytime you tell someone they got to go to a court to get some paperwork, they think it's in court, and rightly so. So these are the reasons why banks typically suck at estate planning. They're very good for what they do. Now, I am going to applaud the whole reason behind it is, look, last statistics I saw, 73% of the people in this country have absolutely no estate plan that's written out, that they put together themselves. Banks kind of responded to this probate crisis with everything having to go in probate by saying, all right, well, look, technically, when they're setting up an account, there's a contract, and we can say, here's where it goes according to contract, and that can, quote, avoid probate. But it's got all of those other downsides. There's no trustee oversight. There's no age limits. Their contingencies are very limited. We can only offer so much, and we can't give legal advice, even if it's an attorney for our bank. So yeah, banks suck at estate planning. They could be very good at keeping your money safe and even in investing it in some ways. So I hope you found that information useful. If you want to get some good information on how to set up your estate, particularly to avoid probate, then check out our free course at freetrustcourse.com. Go ahead and sign up, get all that information, including the audio and some digital versions of my book, Estate Planning Basics, for free. Check that out. Now, as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.